On this episode of the show, we're going to talk about the difference between tenants in common and joint tenants with right of survivorship. Creating wealth, protecting families, building legacy. This is the Rich Life Lawyer Show. Hey everybody, this is Christopher Small, and this is episode 82 of the Rich Life Lawyer Show. I'm your host. I'm the owner of CMS Law Firm, and I am excited to be here with you today talking about tenants in common and joint tenants with rights of survivorship. Now, this is a very, very important estate planning topic, and it deals with real property, right? So your homes, your apartments, your farm ground, any kind of property. This could be an important factor. It's something to make sure that is right before you pass away, or if you're giving your property away, because if you want it to go to the right people, then these designations within your deeds need to be correct. And I decided to do this topic today because someone came into the office and their sibling had just passed away, all right? And they had owned a property together, this person that was in my office and their sibling, right? Their sister, brother or sister. And this person wanted to know what was going on and what the right course of action was moving forward. Now, these two siblings, they owned this property together, and I told them, well, it really depends on on how the property is held, on how you move forward. One way is going to be super easy, and one way is going to be a little more complicated, and that's where joint tenants with rights of survivorship or tenants in common comes into play. Now, let me just tell you what each is, and I'll tell you how it makes a difference within the story that I just told you. So joint tenancy with rights of survivorship basically automatically turns over the property to the co-owner when one person dies. It's automatic, right? It just happens. And that's easy. That in fact is what most deeds, that's kind of the default language, is to be joint tenants with rights of survivorship. If you're not sure, you can always just go and look at your deed and it will tell you what's on there, okay? Tenants in common, on the other hand, own half each of their property as like halvesies, right? So person A owns half, person B owns half. They can do whatever they want with their half, and person A can do whatever they want with their half. When someone dies within a tenancy in common, then person B's property, his half, for example, goes down to his heirs. It doesn't automatically vest or turn over to the other property owner. So you can see how those two different terms and those two different ways of owning property can have a significant difference in the way that the property is transferred when someone dies. And that's exactly what happened here. So I told the person, look, I'm not going to be able to tell you what you should do until I look at the deed. They ended up owning the property as tenants in common, which means when the sibling passed away, that half of the property is transferred wherever the person's will says it goes. So if the deceased person, if the dead person gave his property to his sibling, then that's fine. It's easier. You still have to go through probate and do some things, but it's the way that the guy gets it. But if you don't have a will, or if the will gives the property to their kids, for example, then that half of the property actually passes down to that person's kids. That can be trouble or difficult to do, because now you have one person that owns half of the property and the children of another person that own the property. They may not want to keep the property. They may not want to do anything with the property. So this could be a problem. And even if it's not a problem, even if the kids want to give away the property, it's not so simple. Maybe we'll talk about that in the next show, but it's important to remember, important to look and understand how you own property, particularly if you own it with someone that's not a spouse, because this can come back and have all kinds of problems later on. All right, so that is the show of the day, right? Joint tenancy with right of survivorship means the property automatically goes to the co-owner. There's no probate, there's nothing, it just boom, it's done. Tenants with tenants in common means each person owns their half individually. And when one person dies, that half goes where they directed. It doesn't automatically go over to the other co-owner. Okay, so remember, I'm Christopher Small, the owner of CMS Law Firm. Despite my young appearance, I've been practicing for 12 years. I love estate planning, I love helping families, and I'd love to help you if you'd like. Give me a call, 206-659-1512. You can email me, chris@cmslawfirm.com, and I hope to hear from you. All right.